Thank you, Mr. Chair and members. And as my witnesses work their way up, I'll go ahead and get started. First, I'd like to thank the chair and committee staff for working with my office on developing amendments for the bill. I believe these amendments reflect the true intent of the bill and are consistent with protecting the wishes of individuals after they pass away, so I will be accepting them. As Californians...
And to be clear, those amendments you'll be taking in the next committee?
Yes. Yeah. Got it.
Thank you.
As Californians increasingly use online services like YouTube, Twitter, Facebook, and email to produce and store information, it is important to consider what happens to all of these digital assets after we die. A recent Zogby poll found that 70% of Americans say their online communications and photos should remain private after they die, unless they give prior consent for others to have access. And 65% of Americans say it is a violation of their privacy if that information is shared without such consent. In the same study, only 15% say that estate attorneys should have the discretion to decide what happens to people's private communications and photos. AB 691 addresses this issue by striking a balance between providing a clear path for fiduciaries to access relevant information to handle the deceased person's estate while respecting the privacy choices of not just the deceased person, but those with whom the deceased was communicating. Thank you, and I respectfully ask for an aye vote. And with me today to testify, I have John Doherty with TechNet, Ali Lang with Center of Technology and Democracy, and Jeff Novak with AOL.
Thank you. You have lots up there. I'm going to allow 3, and you do have a support recommendation. So please, your first witness.
Mr. Chair, thank you. We're going to be very brief. John Doherty with TechNet as a co-sponsor of the bill. Just want to say that California has a chance to pass a landmark bill to handle this complicated and difficult issue, and want to thank your staff and yourself, Mr. Chair, working through some difficult issues. So thank you to Anthony and our partner. And we're also working with the Judicial Council, and so I'll leave it at that. Thank you.
Thank you. Next witness, please.
Thank you. My name is Ali Lang, and I work with the Center for Democracy and Technology, which is a nonpartisan, nonprofit technology advocacy organization. Thank you for the opportunity to speak in favor of this bill. We just want to highlight a couple of things quickly. This bill does a good job of preserving the privacy of the individual by default while still giving an opportunity for access when necessary or when consent is given. Just doing a quick mental survey of the variety and volume of digital data you have, you can see this is an important step to make in terms of protecting privacy while also updating estate law. And so we think this is a good step towards establishing California as a leader in estate law and also providing access to things as needed. So we support the bill.
Thank you. Next witness, please.
Good afternoon, Jeff Novak. I manage litigation, compliance, and public policy issues for AOL and its subsidiaries. We've been at this for 30 years, as long as there's been a consumer internet. We're very supportive of the bill, and we've worked hard both here and in Virginia to come up with just a clear path that helps the providers abide by the privacy expectations that our users and the users of other services have in the privacy of their records and their contents, while also solving for a very discrete use case, which is ensuring that people who've elected to go paperless in terms of their account statements, that there's means by which a personal representative can identify inventory and settle those accounts. We think this is a smart balance. It's a very useful roadmap for people who are challenged with that circumstance, and that's why we support the bill.
Thank you. Next witness.
Mr. Chair, members, Robert Callahan with the Internet Association, also a co-sponsor of the bill. We think it's an important fix in this area of law and would urge your support. Thank you.
Thank you. Next.
Mr. Chair, committee members, Pat Zenzala with KP Public Affairs. I'm here on behalf of Google, who also supports the bill.
Thank you.
Mr. Chair, members, Jeremy Mers on behalf of the California Chamber of Commerce, also in strong support of this bill.
Thank you.
Mr. Chair, members, Ann Blackwood on behalf of Facebook in support of the bill.
Thank you. Other witnesses in support?
Chair and members, Dan Pone with the Judicial Council. Like earlier bills, we've been working with the author and sponsor on amendments to the bill. They've taken a number of our issues and concerns by adding definitions, tried to make it more clear, and we continue to provide technical assistance on that so that we get a bill that's as workable as possible for the probate courts. Thank you.
Thank you.
Samantha Corbin on behalf of the Electronic Frontier Foundation. We definitely agree with the author and the sponsors that there is a definite need for this bill. Have been talking to both, just trying to work out some concerns we have about the actual implementation, and hope to continue to do so.
Thank you.
Ivan Altamura, representing Yahoo. Just like to echo all the comments of the witnesses in support.
Thank you. Any other witnesses in support? Is there any opposition? All right, seeing none, I'll bring it back to the committee. And I will also note that the importance of this bill right now, there's a uniform model law that is out there being looked at by other states. And I think I disagree with a lot of its approach. I know that this author does. For California to weigh in at this point will probably change the direction of that model law for other states. That's the significance of what we're looking at here today. Thank you. Mr. Wagner.
I just want to say for the record, the author has done something that I might not have thought ever was possible, and that's bring a privacy and choice bill that I can support. So I'm going to move the bill.
Remember that. So we do have a motion. Is there a second? Yeah, we need a second. All right, there is a motion and a second. Any further comment from committee members? Seeing none, Mr. Calderon, you may close.
Thank you, and I respectfully ask for an aye vote.
Thank you. And this recommendation, the motion is due pass to Privacy and Consumer Protection Committee, where the author will take the amendments that we've been working on. And I appreciate your willingness to do that and work with us on it. Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner?
Aye.
Wagner, aye. Alejo? Chow? Chu? Gallagher?
Aye.
Gallagher, aye. Garcia?
Aye.
Garcia, aye. Holden? Mainshine?
Aye.
Mainshine, aye. O'Donnell?
Aye.
O'Donnell, aye.
Your bill is out.
Thank you, members.
Thank you. That, I believe, Ms. Eggman. So that takes us to item 12, AB 1193.
Thank you, Mr. Chair and members. It's my pleasure to be before you here today. And first, I'll start off by saying I'm reluctantly accepting the committee's amendments. Assisted outpatient treatment, AOT, also known as Laura's Law, is an evidence-based program that in certain circumstances provides treatment to those who have a severe mental illness. In order to qualify for assisted outpatient treatment, a person with a severe mental illness must first meet the criteria, including presenting a danger to themselves and or others and repeated hospitalizations due to their mental illness. The purpose of the assisted outpatient treatment is to keep people with severe mental illness in the community and in the least restrictive environment. Until recently, only Nevada County operated an assisted outpatient treatment program, but over the 12 months, an additional 8 counties have approved assisted outpatient treatment programs, bringing the total to 9 counties out of 58 that have implemented Laura's Law. Ideally, this will be evaluated in every county in the state of California. AB 1193 will encourage counties to discuss treatment options with those individuals with a severe mental illness who would ordinarily qualify for an assisted outpatient treatment program if one were available. This bill will require that counties that have not held a public hearing on assisted outpatient treatment do so by January 1st, 2018. This bill will also allow a judge of a mental health court, reentry court, and or collaborative justice court to request a petition for outpatient treatment. Finally, AB 1193 will extend the sunset date of outpatient treatment program from January 1st, 2017 to January 1st, 2022. And again, this does not take place of any other treatment program. With the inclusion of Prop 63 funding last year through the legislature, there is enough money to go around for all treatment modalities, and we think this is a real safety measure that, as evidence-based, has shown excellent outcomes. And in my own county, I had lunch with my DA over the weekend, and she was saying she had looked back over the last 10 officer-involved shootings, and 8 of them involved somebody with a severe mental health issue that was not currently in any kind of treatment program, resulting in the death of that person and or the injury of somebody else. So we think this is a very important bill. As it moves forward, we'll continue to try to increase some of the rigor that was taken out. And with me, I have witnesses in support.
Thank you. Witness in support, please.
Yes. What do I have to do here? Okay. Good morning. Thank you. I'm Judge Thomas Anderson in Nevada County Superior Court. I've been presiding over Laura's Law since we implemented it in January of 2009. I've also been a presiding judge of our court, and Before I was on the bench, I was also a head public defender for about 10 years. So I bring a different perspective to this program. But I'm here to speak in half of it because Laura's Law works, and it works incredibly efficiently and effectively. And the highlight of it is, of course, that it saves us lots of money and a lot of court time. It's a critical safety net to prevent forced hospitalizations. It encourages and dramatically increases voluntary compliance with treatment plans. I'd like to just take a minute, and I'll keep it brief, but I'd like to just describe how the process works because there's a lot of misinformation about this program. When someone is referred for a Laura's Law review or processing or petition, it's first received by phone usually or memo to a representative of the mental health department. That person refers it to the treatment provider if they think it's going to meet criteria. So there's the first review level. A mental health provider then goes and seeks to intervene, that is to conduct an intervention with the person, with the client, offering them voluntary services. And this is the most critical part of having Laura's Law in the books, because these are people that you're reaching out to, that you're intervening with, who have not participated voluntarily in their own care. They're rapidly decompensating and likely to be hospitalized, jail, or worse. And what happens is about 60% of those people that are the subject of this intervention accept voluntary treatment when offered in this manner. About 60% accept treatment. It means no further court action is done, and you have a person who was at high risk, was rapidly decompensating, now avoids hospitalization and starts to voluntarily participate in their treatment plan. That's critical, and it's priceless. The next stage of those people who don't accept voluntary treatment at that time, a petition is filed. So then this petition now, alleging that they meet criteria, goes to county council for review and the filing of the petition with the court. Another review process to make sure the person is likely to meet criteria, another screening process. Then it goes to the court. An attorney is appointed for the person, the petition is filed, the person gets to see the proposed treatment plan in addition to having access to counsel. Then they come to court, and it's done quickly because the statute requires 10 days between the filing of the petition and the actual examination by the mental health professional, and the petition has to be heard within 5 days. So the person comes before the court. The court then spends some time at the beginning to make sure the person understands this is not a criminal proceeding, they're not going to be jailed, and do they understand what's being asked. And in my court, we engage in a process with the person to allow them to have a say in the proposed treatment plan. It may be something as simple as, I don't want to go to 5 meetings a week. Will you go to 3? I don't want to take my meds, but will you agree to see the doctor and at least discuss it? We negotiate the treatment plan in order to get voluntary buy-in by the person, give them a voice. If we can get them engaged, our experience has taught us that if we begin engagement, it evolves into full compliance ultimately within a few months. So we have that discussion, and the reality is of 80% of those people for whom a petition is filed voluntarily accept the court order at that stage. 80% accept the court order at that stage. It's probably higher than that, but our division is we have several orders that are put in place where the person isn't there. The statute allows for that under certain restrictions, and then the other are contested hearings. But in the 8 years we've now had Laura's Law in practice, we've only had 5 contested hearings where the person's present. So 5 contested hearings. And a contested hearing takes...
Judge, I need you to wrap up, please.
I will. Contested hearing only takes less than an hour, unlike an LPS hearing, which takes several days, and a jury trial takes anywhere from 10 to 25 hours to put on. A criminal hearing takes the court time of about, anywhere from 10 to 50 hours. So the maximum time spent on a Laura's Law, including in-person reviews over the course of 6 months, is maybe 3 hours. So the time saving is incredible. Monetary savings is remarkable. Our study, for every dollar invested, we're getting a $1.80 return. In other words, it's saving us lots of money. And so with that perspective, that's a perspective we need to grow and take advantage of. And having statewide would allow for more regionalization, sharing of services, and many other savings, which I can go into more detail if any members have questions.
Thank you. Next witness, please, briefly.
Thank you, Mr. Chair. Members, Jim Gross on behalf of the California Psychiatric Association. While Laura's Law, AOT, remains somewhat controversial, the fact is that we're undergoing a sea change. Major counties such as San Diego, Orange, LA on a limited basis have adopted Laura's Law. What we want from this bill, what the author wants from this bill, is for there to be a structured process where the public is directly involved in the discussion by the county as to whether to adopt it, how to adopt it, what the impediments are to adopting it, etc. We have discussed amendments with the chair. The author has decided to take them. I think we have some other questions, including some of the questions regarding the judicial portion of it, but it's very important that the public have that opportunity to educate members of boards of supervisors and to have a discussion with them in public about this, because as the judge indicated, this is working, it saves money, it's a productive process. It is time to take it from the bureaucratic side to an open public discussion about it. We ask for your aye vote.
Thank you. Next witness, please.
Mr. Chairman, members of the committee, Randall Hager for the California Psychiatric Association. I think the previous two witnesses have really summed up a really very good case why this bill should move forward and why Laura's Law should be discussed at the very minimum in each and every county in the state. I would just point out that just this last week, the Substance Abuse and Mental Health Services Administration of the federal government added the AOT model, the assisted outpatient treatment model, to its register of evidence-based practices, following on the Department of Justice having 2 years ago done the same thing on the federal level. So this is a program that we would like to see the benefits disseminated more widely for, and for that we recommend this bill to you. Thank you.
Thank you. Other witnesses in support? Please give your name, your affiliation, and your support, please.
Stuart Thomas on behalf of the California Medical Association in strong support.
Tim Madden, representing the California chapter of the American College of Emergency Physicians in support.
Judy Wolin with California Hospital Association in support.
Rebecca Gonzalez, National Association of Social Workers, California chapter in support.
Douglas Dunn, Naomi Contra Costa, support.
Thank you. Any other witnesses in support? Any witnesses in opposition?
Good morning, Mr. Chair and members. My name is Farah McDade Ting from the California State Association of Counties. I want to thank the Assemblymember Eggman for working with us on some of our concerns on this bill. However, we remain in an oppose unless amended position. Everything that the supporters have said about Laura's Law is true. In fact, the California State Association of Counties supported the original Laura's Law bill back in 2002, and we strongly support the right of counties to examine this issue, to hold public hearings as the Laura's Law currently in statute provides, and determine whether Laura's Law or assisted outpatient treatment meets the needs of their unique communities. That is current law. This bill would require a Board of Supervisors to hold a hearing on this issue. The supporters talk about having an open process where constituents can voice their either support or opposition for assisted outpatient treatment. I would say that that exists today. Again, each county can determine whether they want to implement Laura's Law, hold a hearing, see if they have the fiscal wherewithal to do so. We do support in this measure the extending the sunset date of Laura's Law. Again, we are supporters of that, and we do like that portion of the bill. Lastly, we have concerns about allowing judges to refer people for assisted outpatient treatment. It's similar to other issues we've addressed in conservatorship bills in this committee the last couple of weeks, in which we believe a mental health professional should make the referral, which again is current law. So for those reasons, CSAC is opposed unless amended to this measure. And again, I want to reiterate, we do support Laura's Law treatment methods for those counties that believe it meets the unique needs of their communities. Thank you.
Thank you. Next witness, please.
Adrienne Schulten, representing the County Behavioral Health Directors Association of California. We represent the public behavioral health authorities in counties throughout the state. We also have an opposed unless amended position on this bill. I just want to be clear that we do support the extension of the sunset date. We're also not opposed to local implementation of Laura's Law. What we are opposed to is the mandate. Under current law, let me be clear, counties already have the authority, working with their Board of Supervisors and with their local stakeholders, to decide if Laura's Law is right for their communities. So for those reasons, we are opposed unless amended.
Thank you.
Mr. Chairman and members, Rusty Selix for the California Council of Community Mental Health Agencies and Mental Health America of California. Opposed for the reasons stated by the counties, but also for the elimination of the finding that implementation of this program would not eliminate voluntary services. To serve with limited funds, to serve somebody voluntarily is going to be more effective and cost less. This program should be reserved for only that very narrow group of people, but for this treatment, the county makes a finding that they're going to be hospitalized and spend more on them. This bill eliminates the requirement that a county make those findings, which potentially allows this program to be used for people who could be served voluntarily. We think that's bad policy.
Thank you. Other witnesses in opposition, please state your name, affiliation, and your opposition.
Eduardo Vega, President and CEO of Mental Health Association of San Francisco. In addition to the principles stated, I want to point out that we already
I need you to just state that you're opposed to the bill. We've had 3 witnesses already talking in opposition and explaining the opposition. So at this point, I just need name, affiliation, and that you're opposed, please.
Mental Health Association of San Francisco Bay, opposed to this bill.
Thank you.
California Association of Mental Health peer-run organizations representing mental health consumers around the state, opposed to this bill because it strengthens a vehicle we don't think is helpful.
Thank you. Anyone else, please?
Jolena Voris with the Urban Counties Caucus, also opposed unless amended to the bill. Thank you.
Thank you.
Evelyn Abelhassan with Disability Rights of California, echoing the comments of Mr. Selix around the findings to ensure that voluntary services are not reduced, and also the piece about the judges making the determination when they don't really know the individual involved. Thank you.
Matt Gallagher, Youth Advocate for Mental Health America of Northern California, also in strong opposition, and respectfully ask for your no vote. Thank you.
Thank you.
Stephanie Ramos, Mental Health America of Northern California. I'm also the sibling of a young person with a severe mental illness, and I'm in opposition of the bill.
Thank you.
Daphne Shaw, I represent the California Mental Health Planning Council, and we oppose the bill.
Thank you. Anyone else in opposition? All right, seeing none, I'll bring it back to the committee. Questions, comments from committee members? Ms. Egman, I want to thank you for taking the amendments, having been through conversations in my county about the same thing. I appreciate Laura's Law, but I do want to make sure that we're leaving it to the counties to figure out how and what's implemented, especially counties that have services that they're comfortable with. So I do appreciate that.
Our goals are the same, sir.
A motion and a second. Zagwin, you may close.
I would just say that our intentions are the same, that counties be able to, that every county have the opportunity, and everybody who lives in every county have the opportunity to be able to weigh in on what we think is an important issue without reducing voluntary services. Again, with a new stream of funding available, we think there's room for it all, and this just adds to the continuum that we think is necessary to provide good mental health services for everybody.
Thank you. Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, aye. Alejo? Alejo, aye. Chow? Chow, aye. Chu? Gallagher? Garcia? Aye. Garcia, aye. Holden? Mainshine? O'Donnell? Aye. O'Donnell, aye.
That bill is out.
Thank you.
Thank you. We are still missing a few authors. I realize, Mr. Ridley Thomas, item 13, AB 1300. And for all members of Judiciary who are probably at caucus, if you would please come to Judish so we could finish up the hearing, we would all appreciate it. Mr. Ridley Thomas, AB 1300.
Thank you, Mr. Chairman. First, I'd like to point out that I've agreed to limit the immunity provisions as stated in the analysis on page 8. I'd like to present AB 1300, which would make clarifying changes to better define the various steps of a 5150 detention process to ensure consistent statewide application and that patients receive the most appropriate care in the least restrictive environment appropriate for their needs. Involuntary commitment laws were crafted some 50 years ago. When written, they did not contemplate non-public hospital emergency departments providing involuntary care. AB 1300 is the beginning of a legislative dialogue that we hope will modernize the system and ultimately improve the delivery of mental health services to those in critical need. With that, in your indulgence, Mr. Chair, we have witnesses who will testify to the merits of the proposal.
Thank you. Your witnesses, please.
Good afternoon. My name is Mike Phillips. I am the Director and Supervising Attorney of the Patient Advocacy Program based out of San Diego County. My office is tasked with ensuring the rights of patients in facilities, monitoring facilities, and to make sure that anyone that's detained on an involuntary hold is done so with an appropriate legal basis. As was just mentioned, the LPS Act governing civil commitment in California is 50 years old, and its intent was, among other things, to end inappropriate commitment, to provide prompt treatment and evaluation, and to safeguard individual liberties. And we are failing that mission. And we're failing that mission because the landscape has changed. The new battlefield has become the emergency room. You'll hear in a moment some clinical stories as to what's going on in the emergency room, but from my perspective, the patient's rights and individual rights perspective, we're seeing individuals who are brought in that should have never been brought in on involuntary holds by law enforcement. We're seeing people that no longer meet criteria, and emergency staff and hospitals are afraid to cut these individuals loose that are no longer meeting criteria for perceived fear of liability. What's happening as a result is people are being detained for days and even weeks until they can be transferred to a psychiatric facility where they can be cut loose immediately upon arrival. On the flip side, we have individuals who desperately need care who cannot be moved along to the appropriate level of care because of barriers that have crept up in the system. The LPS Act has been interpreted differently in all 58 counties, and what's crept in is less often access to care, but more often confusion and barriers to care. This legislation, AB 1300, is based in many ways on Los Angeles County and San Diego County, where I'm from, where we figured out a way to work together, utilize our community partners effectively, and minimize barriers. What we desperately need across the state are more resources, both inpatient and outpatient mental health resources. Until that becomes a reality, this bill will effectively maximize our current resources and bring us back towards the original intent of the LPS Act. Thank you.
Thank you. And with the next witnesses, if you could be brief, there's a support recommendation on this bill.
All right.
Mark Feudernick. I'm a practicing emergency physician in Los Angeles County at an inner city hospital in downtown Los Angeles. And I agree with, I won't go through the details again, I agree with everything that Mr. Phillips just said about the intent of the bill to fix this broken process. And if you'll allow me just a moment to sort of frame the discussion. Every day when I come into the emergency department on shift, approximately 20 to 25% of our beds in our emergency department are housing psychiatric patients that are waiting to move to the next step because of the flaws in the current system. And it works both ways. And you can look at either example. There are people that are being held in emergency departments that have no business being held there, depriving of them of their rights because a non-clinician made a decision to write a 5150 and we're not given the latitude to then release the patients. And then the flip side is patients that will arrive in obvious mental health crisis that clearly need to go to the next step and see a psychiatrist at an inpatient facility, and yet we're waiting for days in order to have someone else come and affirm that very obvious decision. We have the training and we have the experience to tell the difference, and this bill gives us that ability to do the best thing for the patient in each individual situation.
Thank you. Next witness, please. All right. Any other witnesses in support? Name, affiliation, and your support, please.
David Ford for Adventist Health and Loma Linda University Health in support of the bill.
Thank you.
Amber King with the Association of California Healthcare Districts in support.
Stuart Thompson on behalf of the California Medical Association in strong support.
Randall Hager on behalf of the California Psychiatric Association. We have a support and concept.
Thank you. Anyone else in support? Seeing none, any opposition?
Hi, good morning. My name is Kieran Savage Sungwan. I'm from the National Alliance on Mental Illness, NAMI, California. We're an organization of individuals and family members impacted by serious mental illness. We have 62 affiliates in the state of California, and we appreciate the conversations we've been able to have with the author's office about this bill, and we look forward to continuing to work together to address the issue of access to mental health care, including emergency and intensive treatment services. However, we do oppose this bill as written and unless amended. The reason being that this bill would really lead to our families having no safe place to access treatment in most counties. In most counties, the emergency department is the place where a person experiencing a serious psychiatric crisis can access treatment, and this bill would seriously limit that in several ways. The first way is it does allow hospitals to refuse to treat patients with several provisions, one being if the application for detention is not prevented, an individual would not be admitted for detention evaluation for treatment. It also changes many definitions that are in current law so an individual would not be admitted for detention and treatment. It changes the period of 72-hour detention time to begin when an individual is first essentially touched by law enforcement as opposed to assessed for detention and treatment. It also has some very broad immunity provisions that have been discussed extensively in the analysis. I know some amendments have been taken. We still think they're overly broad and would result in serious harm to our families and to individuals with serious mental illness, and so we do remain opposed to this bill. Thank you very much.
Thank you.
Good afternoon, Mr. Chair and members. I'm Farah McDade-Ting with the California State Association of Counties. We do know that Assemblymember Ridley Thomas has a strong commitment to mental health issues. We know you were at the press conference just an hour ago about mental health issues and how the legislature can address these issues. However, we do have a strong concerns position on this measure. The counties are concerned. We understand, and as the supporters mentioned, there are flaws in the current system, and the major flaw that we see, and I think everybody can agree on, is the lack of bed space for folks who do need inpatient psychiatric treatment. This bill does nothing to address that issue, not one thing. We would like to work on addressing that issue together. We also believe that, yes, the landscape has changed. In fact, in the last 5 years, due to this issue that the ER docs have brought to the forefront of having people be in the emergency room for long periods of time, there's been great strides made here in the legislature and on the Senate side on measures to increase mobile crisis unit funding, have 24-hour stabilization units, increase the ways in which counties can use funding for these types of services. So we think there's been a significant progress along with the implementation of the Affordable Care Act. Those things are shaking out right now. The county programs are getting up and running. We think this bill is premature and it goes in the wrong direction. It creates more silos instead of helping folks in mental health crisis get to where they need to go, as well as to evaluate the folks that maybe do not need inpatient psychiatric care. So for these reasons, CSAC has strong concerns with the bill, and we appreciate your time.
Thank you.
Adrienne Schulten, the County Behavioral Health Directors Association of California. We represent the public behavioral health authorities across the state. We also want to thank Assemblymember Ridley Thomas for his commitment and passion to mental health issues, and thank you for being at the press conference earlier today. CBHJ has significant concerns about the bill in its entirety and really feel that it flies in the face of some of the progress that we've been making on the community mental health side. Namely, CBHJ worked collaboratively with Senate Pro Tem Darrell Steinberg to pass Senate Bill 364, which made much needed improvements to LPS and to modernize it. Secondly, we also supported the Mental Health Wellness and Investment Act, SB 82, and counties and community-based providers are stepping up to provide more crisis capacity in their communities. We also have significant concerns about language in the bill about the 72-hour clock and when that starts. And we're also doing a more thorough review of the bill about where it may or may not violate EMTALA, which is federal law, and trumps LPS. So for those reasons, we are expressing our concerns today. Thank you.
Thank you. That's 3 witnesses in detail, so if the other witnesses would just give your name, affiliation, and that you're opposed. Thank you.
Good afternoon, Mr. Chair and members. Savina Tacker with the Consumer Attorneys of California. We thank the author for taking the immunity amendments. We remove our opposition and are now in concerned position. While the amendments are an improvement, gross negligence is still a very high standard. So we'll continue to work with you.
Thank you.
Mac Alger, Youth Advocate for Mental Health America of Northern California, also in strong opposition, and I respectfully ask you for your no vote. Thank you.
Thank you.
Stephanie Ramos, Mental Health America of Northern California, also sibling of a young person with severe mental health condition, and I oppose this bill.
Thank you.
Sally Zidman with the California Association of Mental Health Peer-run Organizations. Our organization is not for or against it. We think it needs more study. It is very, very complex, and just more stakeholders at the table to work out where the ramifications are, what would happen, what would not happen. Thank you.
Thank you. Anyone else in opposition? All right, seeing none, we'll bring it back to the committee. And Mr. Ridley Thomas, thank you for addressing some of the concerns that we had raised. This bill is a bit of a work in progress, which is not my preference to let out of a committee, but I do understand what you're trying to do, and you've heard the opposition. I know you've been working with them. I appreciate that as this bill moves through. Are there questions, comments from committee members? All right, seeing none, Mr. Ridley Thomas, you may close.
Thank you very much for the dialogue. This is going to be a stakeholder-driven process, and our goal ultimately is to improve the quality and care of those that suffer from mental illness must deal with in their lives. So thank you for your work on this effort, Mr. Chairman.
Thank you. I'm still looking for a motion. The recommended motion is do pass as amended to appropriations. There's a motion and a second. If you call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, aye. Alejo? Alejo, aye. Chow? Chow, aye. Chu? Chu, aye. Gallagher? Gallagher, aye. Garcia? Garcia, aye. Holden? Holden, aye. Mainshine? Mainshine, aye. O'Donnell? O'Donnell, aye.
Bill is out. Brings us to item 8, AB 825, Mr. Rendon.